Hi, this is Dr. Stack here, Cora Stack. I'm very concerned there about, I think Mr. Terry Goria there asked a question why did Justice Brian Cregan release Mr. Enoch Burke from prison? And there was a lot of commentary there on it, but I think I think it was it seemed to me to be some kind of a lack of power move, and I don't know, would you call that, particularly when it appears to be the case that the school have got permission to, to put him back into prison again. So was that, I'm the boss, I am the boss, was it an abuse of power, was it? Was it? That's a very serious thing for a judge to do, to kind of gaslight somebody, or play mind games with them, that kind of thing, or like mocking them, kind of thing. That on its own might not be that, but like if there's a pattern of this in judicial conduct, and a pattern of what we might call circular reasoning or blame shifting or things like that, or abuse of power in a judicial position, that's very, very serious. That's like narcissism. I found it, but like that wouldn't be known. Like what narcissism is, most people wouldn't really understand it. But it's extremely concerning. So this, if this was just a once-off kind of power move, but no, there's been allegations. This judge has been coaching the other side. Sure, that's another power move against a litigant in person and things like that. So there's a pattern here of, I won't say bullying, but it's like coercive control of Mr. Burke, allegedly. This is very serious. It's very serious because it's very hidden. But like, if you've studied all of this, in psychology, it's a pattern, and you look at the judgments and the reasoning. And I have looked at a number of the judgments of because of a recent judgment that implicated, I unfortunately was introduced into a judgment, and it was clear it was very circular, and that circular reasoning is it's also um, consistent with kind of a distortion, some kind of a problem with defense, an overly defensive mindset, a real defense, like being at war, kind of, and what the mind is at war with the litigant. So it's very problematic and very concerning. That's all I'm saying. There's a serious matter to be concerned about. Now, it is not Mr. Burke that I have the serious issue of concern with. It's the conduct of this judge, but it's not just a once-off. It's a pattern of a pattern of thinking, reasoning, behaviour, conduct, power games, and treatment of litigants in person in particular. So they're vulnerable. Litigants in person are very vulnerable, so it can be manipulated, they can be mocked, they can be falsely accused, minimised, their concern can be minimised, not heard, and it's most concerning. And then that any judgment by a judge like that can be used then as a precedent, and there could be problematic reasoning there as well. And the judge might not be aware of this problematic reasoning, circular reasoning. But I have looked at a number of judgments of this judge, and there seems to be circular reasoning here. And then if that's incorporated as doctrine into other cases, that hardens the doctrine, so it compounds the logical problem. But it's not that; it's the injustice of the circular reasoning, really, because that's it's a thinking distortion. If someone does the circular reasoning, so it's very difficult to explain it, but it's a cause for major concern here, I think, and I can't do anything about it. But I'm just raising it as a concern that there may be a serious issue here with the thinking of the judge in this particular case, and perhaps in related cases. And this is, in my view, a power move, and it is an abuse of power if if he knew that it was like playing a mind game or with somebody who was in a vulnerable position or a lesser position in terms of he's up there, the judge. So completely and utterly unacceptable. That's how I'm reading it now. That's my answer. Completely and utterly unacceptable. It's not for entertainment. No. It's power imbalance, and that you could argue is an alleged abuse of power. So let's see, could we put this judge into a different judicial role where his talents could be more useful and benefit the outcomes of justice. So how courts decide disputes and how justice can be designed to reduce harm. So I'm Cora Stack. I'm the first Irish recipient of the 2025 Ramanujan Memorial Award for Excellence in Academic Leadership. Most people don't meet the law out of curiosity. They meet it when something has gone wrong. A family breaks down, a home is at risk. The world of people in Dublin in the courts are fighting the banks. It's dreadful. A job is lost. A powerful institution says no. We're here now, and at the exact moment when people most need clarity, safety, and dignity, the legal system often feels confusing, intimidating, expensive, and emotionally damaging. And in a lot of these cases, people can't get solicitors, as we know. The squeezed middle have no access to justice. So what I want to do is explain in simple language how courts actually decide disputes, how legal doctrine really operates, and how justice could be designed to reduce harm rather than reproduce it. What is the dispute? At the heart of every legal case is a dispute. A dispute arises when people or institutions disagree about something that matters in real life. In law, disputes are usually framed as disagreements about rights, obligations, responsibility, or power. Some disputes are deeply personal, involving children, money, housing, safety, or dignity. Others are institutional, involving employers, banks, universities, or public bodies. Institutionals, I met somebody once and she said to me, I never met anyone who won against an institution. That's what she said, so. And some are constitutional. This is very interesting now, just to see what the constitutional disputes are about. They're about the limits of state power and the protection of fundamental rights. So that to me is, that's magic, the constitutional law. It's magic. So legal systems exist in part to resolve disputes without violence, coercion, or endless retaliation. That's what dispute resolution is meant to do. So let's talk about the type of dispute resolution used in courts. It's called adjudication, when agreement is not possible. Now, I have a major problem with this in the judicial side of it, not with the constitutional side of it. Absolutely not. Negotiation and mediation rely on agreement, but not all disputes can be resolved by agreement. While by this form of dispute resolution, standard forms of negotiation and mediation, especially where power is unequal or harm has already occurred. That's where adjudication comes in. Adjudication happens when an independent decision maker, like a judge or a quasi-legal judge, they're very similar this very similar sort of adjudication. For example, in the workplace relations, you have a similar sort of adjudication. Adjudication is used in the workplace relations. Again, it's adjudication. So adjudication listens to the dispute, applies the law to the facts, and makes a binding decision. That's what it's supposed to do. Courts are powerful because their decisions carry authority, finality, and legal consequence. And when courts interpret constitutions, they just don't resolve individual disputes. They define the boundaries of lawful power for everyone. So, as I say, the constitutional, there's something more about the constitutional law, which is about everybody's rights, rather than, there's something more, I don't know, it appeals to me a lot more than the adversarial system, as I'm now talking about it, in terms of its purpose, really. So not all adjudication is equally visible. Non-silent adjudication is transparent. The judge explains what facts were accepted, which legal principles apply, and how the decision was reached. I mean, that's transparent. This supports accountability, legitimacy, and meaningful appeal. But silent adjudication also exists. This happens when decisive reasoning is not fully explained, when credibility judgments are asserted without analysis, or when short procedural decisions quietly determine outcomes. Silent adjudication matters because when reasons are not given, people don't know why they lost, and the system's claims to fairness begins to erode. Doctrine, what courts say and what they don't. So this is a very interesting part of law, doctrine. Courts don't decide cases from scratch. They rely on what is known as doctrine. Doctrine consists of the rules, principles, and tests developed over time. Some doctrine is visible and explicit: burden of proof, standards of review, precedent, proportionality. But alongside visible doctrine operates something far more powerful: silent doctrine. Silent doctrine consists of unspoken assumptions that calm people are credible, unfortunately, that distressed people are unreliable, that institutions are neutral, that conflict is mutual, even when power is not. These assumptions are rarely named, but they shape outcomes decisively, and because they're invisible, they're incredibly difficult to challenge. Let's look at the adversarial system now. Most courts offer through an adversarial system. I am very much against the adversarial system, no question, particularly because of our current access to justice issues with regard to legal representation. Absolutely against it, and I can't see it improving. In fact, I can't see it improving given the escalation, the huge escalation in legal costs and the complexities of disputes. I don't see it as being able to solve disputes anyway. So I see it as, it's just if it's a game of traps, it's long past its expiration date. It's outrageous. And an outrageous dispute resolution system, which is very slow to move towards arbitration. And I think there's arbitration law coming into commercial disputes, imagine. And that's going through I understand that's going through the door at the moment. So the big, powerful players are able to get arbitration. And the most vulnerable of litigants, that go in there, families, nobody's fighting for arbitration for them. Absolutely outrageous. So each side fights its case. The judge there should be no arbitration law decided upon until all cases, all law that can go through arbitration. So there should be a ban on this constitutional arbitration amendment until all law goes through arbitration, and trauma arbitration, as I'm saying. And, that's one thing that should happen now. Most courses, there should be new bills brought in. No special treatment for commercial litigation until arbitration, appropriate arbitration is introduced for all dispute resolution systems. Dispute resolutions first. So most courts operate through an adversarial system. Each side fights its case. The judge decides who wins. The system has strengths, but it also escalates conflict, as we see in the Burke case. I mean, to think a judge would get involved in a power struggle with someone who was, by definition of the system, much more inferior in terms of the power imbalance. That's absolutely, it's unbelievable. If allegedly this is what's going on here, kind of mocking it's horrendous. Power game, or mind game, if you like, if you want to call it a mind game. I don't know. I'm just alleging that it's most concerning what has that going on here. Very, very concerning. If there's a pattern of it, it's kind of like bullying, allegedly, like a bullying power game. Isn't that what bullying is about? This kind of coercive control, allegedly. So this system has strengths, but it also escalates conflict, rewards resources and confidence, and often mistreats trauma as unreliability. Mediation can help, but only where participation is truly voluntary and safe, and where you don't sign off, you don't sign off a lot of your rights, in in a way that they're not explained to you. So there's sneakiness stuff can be going on in mediation unless you know exactly what you're signing, and often things are going on behind the scenes. Games between solicitors are going on behind the scenes, and you could find yourself in a situation where you end up very badly out of a mediation situation because you're not, there's too much of an emphasis on on the legal costs, and not enough on the outcome for the person. So that you have to be very careful going into a mediation process that you're not ripped off by solicitors, if that's what's happened. So I'm not saying it happens in all cases. It can be very effective in some cases. Arbitration can be efficient, but only when properly designed and accountable. No single process fits every dispute. So what I'm going to do now is I'm going to look at a different possibility: trauma-informed problem-solving arbitration. So this is where I'm coming in here now. The pictures here are fabulous, but unfortunately I can't put them in. This is where I have tried to introduce this idea that dispute resolution needs to move from this adversarial win or lose to a problem-centered approach. And interestingly, one of our best journalist was talking about that we needed more engineers than lawyers, and actually it was really an interesting point, because engineers are problem solving. So when I saw that, sure, that's what I'm talking about. So that engineers are good problem solvers. So would they not be good in an arbitration? But of course they'd have to be trauma informed, but they could have legal people obviously are needed as well. So you need the engineers and the lawyers and the expert trauma people who are experts in psychology, in trauma-informed psychology. So many disputes are not caused by a single bad act. They arise from interacting pressures, financial strain, burnout, communication breakdown, health challenges, lack of support, unresolved conflict. I mean, there's every there's betrayal, there's a lot of things that are involved. A lot of betrayal, grudges, people are unresolved. Conflict is a very difficult thing to define. It can happen over a long time, and a breakdown of communication you often hear, which is often just build up of unresolved conflict, or an ability to resolve conflict. And then there's a breakdown of the communication because of an inability to resolve conflict over a period of time. And then a dispute resolution will try and see, well, is there any way we can, all these problems with breakdown and conflict which have led to a complete collapse, is there any way we can solve the problems? Or what happened here? How can that be solved? What happened here? And then see, can we turn dispute resolution into a problem-centered? That's arbitration. That's my kind of idea. Traditional adjudication turns these into weapons in a win-lose contest. A trauma-informed problem-solving arbitration model offers a different approach. It's authoritative, it's structured, it produces reasoned, binding outcomes, but it asks a different question: what went wrong and what would reduce further harm? Trauma-informed does not mean soft, it means accurate, it prevents domination, it recognizes power asymmetry, it avoids mistaking trauma responses for deception. Justice should not be measured only by who wins. It should be measured by whether the dispute is actually resolved. Closing. Disputes are signals. They tell us where systems have failed, where harm has accumulated, and where redesign is needed. A just legal system does not simply decide disputes, it learns from them. My name is Dr. Cora M. and thank you very much for listening.